Hi everyone, and welcome back to our Chapter 9, Basis of School Law, Part 2 of the PowerPoint. It's only 3 slides on this one, so a bunch of information about legal responsibilities of states and school districts, which come under this particular PowerPoint because, again, we're in the law chapter, and states and school districts have a responsibility to legally accomplish a number of things. One of them is school desegregation, which you can see right here on this slide. And there's what school desegregation means is that schools need to be working toward integrating their student populations with a variety of backgrounds. So there is some background information related to school desegregation on this slide that I'll give you just a little historical perspective. Back in 1896, there was a court case known as Plessy versus Ferguson, which had to do with railroad cars, actually, unrelated to schools particularly, but in that case, there was the argument that if railroad cars were equal in what they were like, let's say windows and the kinds of seats in them, then they could separate people by races. A railroad car for white race and a railroad car for the African American race, let's just say, for example. And that's what was going on during that time with the Plessy versus Ferguson case, is the idea of separate but equal was okay. That's what the ruling of that case was when it came to specifically railroad cars. The idea here of it's called de jure segregation really has to do with segregation that's allowed by law. So I'll repeat that. Segregation that's allowed by law is known as de jure segregation. That was a term that was utilized, of course, after this Plessy versus Ferguson case because it was still legal to segregate something, whether it was railroad cars or something else, including schools. Then when we came to the 1950s, in 1954, we had a court case called Brown versus the Board of Education of Topeka. And hopefully you remember this from one of our prior lectures, because I said if you remember any other court case, this is the one to remember. It was a landmark court case of significance in that this case dealt with a family by the last name of Brown who were African American. They wanted to attend a school that was closer to their home. However, they were not allowed to because of segregated schools, which were allowed by law prior to that time. And as a result, they had a case, brought their case to the court, which then ruled that separate but equal was unconstitutional, and that segregation was basically violating the equal protection of the 14th Amendment clause, which we talked about the 14th Amendment in our prior basis of school law PowerPoint, if you recall. So at this point, segregation was not legal anymore. And so a term that we use now called de facto segregation really has to do with segregation that still exists, not because the law allows it, but because it's kind of this natural segregation that has still continued over the years, where individuals from certain backgrounds and races have seemed to choose certain neighborhoods to reside in. And so groupings of certain individuals from similar or the same backgrounds tend to almost segregate themselves within their communities. It's kind of this natural form of segregation. So not segregation allowed by law, but a natural kind of form that happens. In addition, when it comes to states and school districts legally being responsible to make efforts to desegregate their districts, there was this test of progress that came about from a court case. I'm going to flip to the next slide here so that you can see this court case in 1976, Greene County School Board of New Kent County. This was a case having to do with segregation, and it came up with these, what we call 6 tests of progress. So a school district, in order to answer the question, is my school making progress toward integration? Do we meet these criteria? Do we have a racial balance? Do we assign students to certain schools in equal amounts based on their racial backgrounds? Transportation parity is where, when schools in a district, if there are a number of schools trying to integrate more and desegregate, are they busing certain students to faraway schools, or busing more of one student group to a school versus another student group? They're looking at, is it fair of the students who are getting bused or moved around to other districts in the schools in the district in order to promote desegregation. The third test of progress is this: are the facilities equal? Facilities meaning the physical buildings of the school district. And by buildings, is one school in better shape than another when it comes to the windows, the classrooms, the desks, just the physical buildings themselves, the heating systems, all those kinds of things. Equity and resource allocation is the fourth test of progress. Well, the school district must ask themselves, do we have allocated equal amounts of money to all of the schools in our school district? Is it equitable and equal? And then equity and personnel placement has to do with the actual teachers and staff in the schools within the district. Do we have both majority and minority teachers and principals in each building? Is there a good representation of minority and majority personnel? And then the last one is equal access to extracurricular activities, and this has to do with what is offered in every school within a district. Are they comparable activities, and is everything available to every student no matter what school you go to in that district? So these are kinds of things that, going back to the last slide, are these tests of progress having to do with school desegregation. In addition, a couple of benefits and long-term effects of schools being desegregated are always positive, such as in schools that are truly desegregated, we have students who achieve higher college attainment and also have higher occupational aspirations as well. So always those are positive things. Our last slide has to talk about two other areas of legal responsibility that states and school districts have. The first one being school accountability. Schools are being held accountable for things like what diploma requirements they set for students, as well as what we call educational malpractice suits. Think of a doctor. You've heard the word malpractice before, where doctors, let's say, harm a patient in some way. There are malpractice court cases or lawsuits that people file against doctors for that reason. This is kind of comparable to that when it comes to education. What that means is, if we graduate students from high school who without basic skills, who don't have what's necessary to get a job, to become a productive member of society, then have we as an institution, a school, not done our job, educational malpractice. And then the other piece of school accountability is schools are legally responsible, and school districts, to test students at certain grade levels. There's mandatory testing, and that's for us to see how well students are doing. And that's part of the accountability issue, but it's also a legal responsibility that schools must undertake. Okay. The last area about legal responsibilities we need to look at quickly all have to do with money, law, and school finance. And this has to do with, for example, property taxes. Schools are funded by property taxes, and is there an equitable distribution of those taxes no matter where the school is located? So remember, when we talk about schools in suburbs versus inner cities, the tax base based on property taxes tends to be broader when the values of the property in that area are higher, usually in suburbs, than Do those areas get more money than, let's say, urban or inner city areas where property values are worth less, and so would the schools then not get as much money? A second issue related to school finance is the tax and spend issue, where we look at wealthy versus low income families, where tax and spend, when we tax those making more money, it tends to be low, and as a result, more or high amounts can be spent, whereas those who are on the low income range, we tend to have taxes that, because they make less money, percentage wise, it seems to be a tax that's high for them, and then there's very little left to spend. So this low, high, high, low when it comes to wealthy for the low, high formula, and the lower income for the high, low formula. Again, is there an equitable kind of way to work that out when it comes to school districts and money that's utilized for them? Okay. And then the last piece is, are all the schools within districts providing adequate educational opportunities? It should not just be affluent or wealthy schools providing, certain programs or guest speakers, or having, specialized equipment where other schools do not have that. So the states and school districts within those states are legally responsible to make sure that these opportunities are given across the board to all students in all districts, whether wealthy or not. So these are issues that, again, are the legal responsibility of states and school districts. Okay, so that's the end of the second part of the Basis of School Law PowerPoint. Hopefully I'll see you guys back here for another one when we talk about the legal rights and responsibilities of teachers, and then the legal rights of students, and then the legal rights and responsibilities of parents. So see everyone again.